Hi guys! Welcome to another episode of Attorney Job Vlogger, Law for the Everyday Layman. Today, we'll take up the topic of murder versus homicide. What's the difference? So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? Now, in order for us to properly distinguish murder from homicide, we also have to talk about some interrelated crimes, no? Let's begin with parricide, okay? So what is parricide? Parricide, simply put, is the unlawful killing of the father, mother, or child, no? Whether they be legitimate or illegitimate, okay? Now, it can also involve the unlawful killing of a spouse, or other ascendant, no, like a grandparent, or descendant, like grandchild. But in case of spouse, ascendants, or descendants, they have to be legitimate. Okay? There has to be a legitimate tie, no? Now, if the person killed is an illegitimate grandfather or illegitimate grandchild, then it's not parricide, but it may be murder or homicide, as the case may be. Okay, the essential element of this crime of parricide is relationship, no? It must involve the killing of a father, a mother, or a child, whether legitimate or illegitimate, or in case of the spouse, ascendant, or descendant, they have to be legitimate. Okay? Now, let's also talk about infanticide, no? Infanticide is the unlawful killing of any child less than 3 days old. Okay? It has to be less than 3 days old. Now, the killer, it can be the parent, can be the grandparent, or any other relative of the child, or even a stranger, as long as the child is less than 3 years of age. Now, what if the crime is committed by the mother or maternal grandparents, no? Then, in that case, the penalty is mitigated or lowered. But in a different case, the penalty will be the normal range. No, it will only be lowered if the offender or the accused is either the mother or the maternal grandparents. Okay? Now, this crime of infanticide is different from intentional abortion. The Philippines punishes intentional abortion. Okay? Where the person who performed the abortion is liable. The woman, who is pregnant and asks for the abortion will only be liable if she consented to the abortion. Because there may be unintentional abortion, that's also a crime, in which case the offender or the accused, the one who caused the abortion, will be liable, no? Now, the law also punishes abortion if practiced by the woman on herself or by her parents on the pregnant woman. Okay? The law also punishes abortion practiced by a physician or doctor or by a midwife, and the dispensing of abortives or substances which can cause abortion. Okay? So those are all punished. Now, whether it be parricide, as I discussed earlier, or infanticide, the penalty is reclusion perpetua, no? Or 20 years and 1 day to 40 years, no? The judge now will decide what is the actual length, no? But anywhere between 20 years and 1 day to 40 years, okay? Since the death penalty has been repealed, so we don't apply the death penalty, only that of imprisonment, okay? Now we can go to the topic of murder. So what is murder, no? Murder is simply the unlawful killing of any person which is not parricide or not infanticide, which is why I had to discuss the two earlier, no? It's the unlawful killing of any person which is not parricide or infanticide, provided any of the following circumstances is present, no? You will know it is murder if there are certain circumstances that are present in the unlawful killing of the victim. Okay, let's discuss the first, no? If the killing is committed with treachery, that's murder. And how do we know there's treachery? It's if the offender or the person who did the killing, he employs means or methods which tend directly and specially to ensure the execution of the offense, no, to ensure the killing without a risk to himself, to ensure the execution of the offense without the risk arising from the defense made by the victim. Okay? In other words, the victim should not have had means or no available means to defend himself. Such as when his hands are tied, no, he cannot defend himself. Or when he is shot from afar by a, let's say, a sniper. Okay? Or there is a deliberate surprise attack. That's treachery. But in order for those to be considered as treachery, the means that is used to commit the murder must be consciously adopted. Okay? In other words, the offender really thought that, hey, I will shoot this person from afar so that there will be no risk to myself from the defense that the victim may take. Okay? Now, another circumstance would be taking advantage of superior strength, or the killing is done with the aid of armed men. Okay, men with arms, no, guns, knives, whatever. Okay, in these two circumstances, the offender or the killer, he must take advantage of his superior strength, no, being strong, or because he has a weapon, no, okay, or of the armed men. Okay, so there must be evidence, okay, of relative physical strength, that the offender is stronger, or there must be evidence of the number of aggressors who participate. Okay, it does not apply if the armed men are just watching, no, they have to participate in some manner. Okay, and another example would be if the weapon is out of proportion to the defense available to the victim. Let's say the victim can only defend himself with his hands and the offender uses a knife, then that's out of proportion. Okay, or even if it's a gun or worse, no. Okay, so another circumstance would be employing means to weaken the defense of the victim, no? So if the offender throws cloth or cloak or blanket over the head of the victim, so his defense is weakened, he does not know how to defend himself. Or he throws sand in the eyes of the victim, or gets the victim drunk, no? Then these may be considered as means to weaken the defense of the victim, and if the victim is killed, then that will be murder. Okay? And finally, it can be by means or persons to ensure or afford impunity. And what does impunity mean? It simply means exemption from punishment or freedom from injurious consequences, no? Simply put, when a person wears a mask in order to avoid detection or revealing his identity in order to kill someone, then he is ensuring impunity, no? So he won't be known right away. Okay? Let's go to the second set of circumstances, no? If the killing of the person is done in consideration of a price, reward, or promise. Okay? Now take note, no? The price, reward, or promise, no, must be for the purpose of inducing the killer, no, to commit the murder. Okay? In other words, it should not be the case where the murderer already decided to kill a person and then it just so happens that he received a reward after. Okay? It does not apply in that case. The murder must have been committed because the murderer was going to receive a prize, a reward, or a promise. Okay? Now, let's go to the third set of circumstances, okay? If the killing of the victim is committed by means of inundation or flooding, by fire, poison, explosion, shipwreck, stranding of a vessel, derailment or assault upon a railroad like the MRT, LRT, no? Fall of an airship, if it is committed by means of motor vehicles, or with the use of any other means involving great waste and ruin, then that will qualify the killing to murder. Okay? Now, all those things I mentioned they must be used for the purpose of killing someone. Otherwise, it may be a different crime, such as in the case of fire, it may just be arson. If the purpose was not to kill a particular individual or individuals, no, it will simply be arson. Or it can also be terrorism, no, under the Human Security Act, or in this case, no, the present time, no, the anti-terror bill. Okay, so let's just wait to see what happens with that. But to move on, no, let's go now to the fourth set of circumstances. Okay, so the fourth set talks about a killing which is made on occasion of any of the calamities that I just mentioned, no, inundation, fire, derailment of a locomotive, no, etc., no, or on occasion of an earthquake, of eruption of a volcano, destructive cyclone, epidemic like COVID-19, or any other public calamity. Okay, why do these circumstances qualify the killing of a person to murder, no? Why? Because the offender or the accused, instead of lending aid to those who are affected by the calamity, the offender, he adds to their suffering by taking advantage of their misfortune. Okay, so in order to qualify the killing to murder, advantage must be taken by the offender of the calamity. He sees, hey, people are suffering from this earthquake, now I can kill this person. That will qualify the killing to murder. Okay, now let's go on to the fifth set of circumstances, no? If the killing is committed with evident premeditation, okay, then that qualifies the killing to murder. Okay, and how do we know it's evident premeditation? No, evident, you can see it, no, or you can readily observe it through any of your senses. No, premeditation, you thought about it and really reflected upon it, no, on the plan. Okay, so there must be deliberate planning before the execution of the killing. Okay, the essence is that the execution must be preceded by cool thought, okay, and reflection. You were able to really think about it, and you reflect on the decision to carry out the killing, okay, during a space of time sufficient to arrive at a calm judgment. Okay, sufficient time must have lapsed. No, you were able to think about it. Should I really do this? Yes, I will really do this. Then that will now be evident premeditation. Okay, however, there must be proof of the time when the offender determined to commit the crime. Okay, there must be evidence of an act manifestly indicating that the accused clung to his determination that he will really do it. No, and there must have been a sufficient lapse of time between the planning and the execution to allow the offender or the killer to reflect on the consequences of his act and to allow his conscience to overcome his criminal resolution. In other words, there should be time for him to think, no, this is against the law, I shouldn't do this. Okay, so there must have been sufficient time. If all those elements are present, then that will qualify the killing to murder. Okay, so in other words, no, if the accused armed himself with a weapon, like let's say a bolo, no, and he walks for a whole day and a whole night to arrive at the next town and he killed 2 people, then there is planning, no, there is evident premeditation, and the length of time that he walked for 1 whole day and 1 whole night gave him enough time to really reflect, will I really kill some people? Okay, he should have desisted, no, but he did not, and instead he killed the people, and so he is liable for murder. Okay, so how do you know that there is planning? No, there must be a manifestation by external acts, because we cannot read the minds of people, no, so we can only determine that he had the plan when he makes external acts. So some examples, no, if you prepare the weapons, no, you laid out several guns and daggers to use, or the offender had previously dug a grave, no, for the person he intended to kill. Okay, and before he killed that person, no, so those would be some examples of plans. But take note, no, the planning does not have to involve the killing of a particular person. just the plan that he wants to kill anyone. That will be sufficient. That will be enough. Okay? Evident premeditation qualifies the killing to murder. Okay? And finally, let's go to the sixth set of circumstances. The sixth set of circumstances talks about cruelty. No? Cruelty by deliberately and inhumanly augmenting the suffering of the victim. In other words, the accused or the offender, he enjoys and delights in making his victim suffer slowly and gradually. Okay? And causes the victim unnecessary physical pain. It has to be physical. Okay? The offender, the accused, must have had the intent to prolong, pahabain yung suffering of the victim and cause him unnecessary physical pain. Okay? So there must be evidence that the injury was deliberately increased by causing another wrong or another act which is unnecessary for the execution of the criminal act. And some examples, no? The offender was going to kill the person but he still had to gouge the eye out. Okay? Or if the mouth was burned or the mouth was stuffed with mud. Okay? So in those cases, those are some examples of cruelty. Okay? And aside from cruelty, it can be done by outraging or scoffing at the person or the corpse. Take note, even the corpse. So in case a person or the victim is killed and then a deeply insulting act was committed against the corpse, such as the corpse was raped after it had been killed, okay, or if the corpse had been dismembered, no, its body parts had been cut, then that will qualify the killing to murder. Now, those circumstances I mentioned, no, if any one of them is present, then the crime is automatically murder. Okay? Now, what if there are more than one circumstances present, no? Like evident premeditation and adding outrage to the corpse, no? By dismembering it, no? There are two. In this case, only one will qualify the killing to murder and the other may be used as an aggravating circumstance. And what is the effect of an aggravating circumstance? It increases the penalty up to the maximum of the offense. Okay? Except, no, in case the aggravating circumstance is absorbed in one or more qualifying circumstances, such as nighttime may be absorbed in evident premeditation, and you don't count that anymore to make the penalty heavier. Okay? But if they are different, the existence of other circumstances will make the penalty heavier and he stays in prison for a longer time. Okay? So, in the case of murder, the victim must be killed. Okay? Otherwise, if he survives, it may either be attempted or frustrated murder. I'll talk about the different degrees of attempted, frustrated, consummated in another video. Okay? And in case of murder, no, consummated murder, the penalty is reclusion perpetua, anywhere between 20 years and 1 day to 40 days. 20 years and 1 day to 40 years. Okay, and it's up to the judge to decide the actual duration. Okay, so that's it for murder. Now let's go on to homicide. Okay, what is homicide? Homicide is the unlawful killing of any person which is not parricide, it's not infanticide, and it's not murder. Okay? So that's how easy it is, no? The distinction between murder and homicide is simply the fact that homicide does not involve any of the circumstances in that I discussed in murder, no, like treachery, evident premeditation, cruelty, etc. No, it also does not involve the killing of a baby less than 3 days old, and it does not involve the killing of a relative, as in parricide. Okay, so in order for a killing to be considered homicide, there must be no justifying circumstance like self-defense, no? In other words, a justifying circumstance, no? In that case, the law says that there is a crime, but that act of committing a crime is justified, such as self-defense. I'll talk about self-defense in a different video. Okay? But in order for the crime or the killing to be homicide, there should be no justifying circumstance. And in case of homicide, as long as a person is killed, then the intention to kill is presumed. Okay? The intention to kill is presumed, and the defense will have to prove that there was no intention to kill. However, in case of attempted or frustrated homicide, the general rule is that the prosecution must still prove intention to kill. Okay? But in consummated homicide, where the victim is actually dead, then the intention to kill is already presumed. And the penalty for homicide is reclusion temporal, no? Or 12 years and 1 day to 20 years. Okay? Now, let's talk about some other points. Now, I want to discuss some other points. Now, what if there are several persons who are not part of groups which are organized for the common purpose of assaulting or beating each other up, no? And these people, they quarrel and they assault one another in a confused and tumultuous manner. And in the course of that fight, someone is killed, okay? But you cannot determine who killed the victim. Is there a crime committed? Yes, no? Okay? First, if the person or persons who inflicted serious physical injuries or who used violence can be identified, they may be prosecuted for the crime known as death caused in a tumultuous affray. Okay? Death caused in a tumultuous affray. And the penalty here is prisión mayor, anywhere between 6 years and 1 day to 12 years. But if you cannot identify those persons, no, then there's a lower penalty. It's just prisión correccional, which is 6 months and 1 day to 6 years. Okay? And that will be imposed on all of those people who use violence upon the victim. Take note that in case of death caused in a tumultuous affray, there must be at least 4 persons, no? 2 persons on one side, 2 persons on the other, no? Or in any whatever combination, no? There must be at least 4 persons, and there must be no organized or well-known groups. If the groups are organized and they are united in a common purpose to attack each other, then the crime may be homicide or even murder if applicable. Okay? So it will no longer be that death caused by in a tumultuous affray, which has a lower penalty. If the groups are organized and there is a common design to kill someone or the other group, then the crime is heavier and the penalty is heavier. It may be homicide or murder, as the case may be. Okay, let's talk about suicide. No, the act itself of suicide or killing oneself is not punishable. Okay, the suicidal person will not be punished for attempting to kill himself. And especially if he kills himself, how will you punish him? No, he's dead, no? Okay? I'm not, apologies if it seems like I'm taking it lightly, but suicide is a very serious matter. If you need help and you're considering suicide, please contact the available hotlines, no? And talk to someone, no? Suicide is a very big deal, no? And depression as well, no? So, when it comes to the topic of suicide, the person who committed suicide itself is not liable. But if another person assists another to commit a suicide or lends his assistance to another to the extent, no, that as if he has committed the killing himself, whether the person dies or not, then that person who assisted will be liable for the crime of assisting in suicide, no? In case of simple assistance where he does not do the killing himself, the penalty is prisión mayor, no? It's 6 years and 1 day to 12 years. But if the assistance which is lent is up to the extent of almost doing or actually doing the killing himself, then the penalty is reclusion temporal. It's heavier, okay? It's 12 years and 1 day to 20 years, okay? Now, if the person does not die, then the penalty is lower. Okay? The penalty will only be arresto mayor, anywhere between 1 month and 1 day up to 6 months. Okay? Now, take note that suicide is different from giving assistance to suicide. The crime of giving assistance to suicide is different from euthanasia. Okay? And euthanasia is the medical practice, no, of painlessly putting to death a person who is suffering from some incurable disease. The law under the Philippine jurisdiction does not authorize euthanasia, okay? And the doctor who resorts to euthanasia may be held liable for murder, okay? Of course, it depends on the facts of the case, okay? But according to a prominent author of criminal law, the doctor may be liable for murder in case he performs euthanasia, okay? The final topic I want to talk about is duel. Okay? And what is a duel? You may have seen this in movies where there are two people who have a disagreement and they have guns. They turn around and they have seconds who watch them, no? They turn around, walk a few paces, and then suddenly face each other and shoot each other, no? Okay, and the duel is defined as a formal or regular combat, okay? Previously agreed to between two parties in the presence of 2 or more seconds of lawful age on each side, who make the selection of arms and fix all of the conditions of the fight. Okay, it's formal. It's a formal agreement. Now, if one of the duelists is killed, no, he gets shot, okay, or he gets stabbed, whatever, no, then the offender may suffer the penalty of reclusion temporal, anywhere between 12 years and 1 day to 20 years. But the penalty will be lower if one of the duelists only suffers physical injuries. Okay? Now, what if no one dies? If no one dies, then they will still be punished because the act of duel is punishable. Okay? So the duelists will be punished with arresto mayor, anywhere between 1 month and 1 day to 6 months, while the seconds, those who are like the assistants of the duelists, they will be liable as accomplices. Okay? And finally, we have the crime of challenging to a duel. Okay? And this includes the actual challenge, no? Or inciting another to give or accept a challenge, no? Like, hey, come on, let's duel, no? Okay? Or scoffing or decrying another publicly for having refused to accept a challenge to fight a duel, no? Like, pinapahiya mo siya, no, you're not a good guy because you don't want a duel, no? Like that, no? Okay? And in case of challenging to duel, no, the penalty is prisión correccional, anywhere between 6 months and 1 day to 6 years, no? And this is different from a mere challenge to fight, no? You know, when kids say, oh, lika, or simply saying, let's have a fist fight, no? That's not a duel, okay? Because duel, as I emphasized earlier, a duel is formal in nature, okay? And the invitation to fight, okay, may simply be a crime of light threats, or it may even be as low as unjust vexation. Okay? So please take note that the penalties I mentioned earlier I just gave the general, no? Of course, it may be longer or shorter as the circumstances of the case may allow, no? And the law itself gives certain qualifications, no? Like prison correctional in its medium, maximum. Those are technicalities best left to lawyers and or judges, okay? The purpose of this video is simply to give a general idea on the difference between murder and homicide, as well as the other related crimes, okay? So I hope you may have picked up a thing or two, and I hope to see you in my next episode. Okay? See you soon. Bye.